1, 2. Yeah, it's better. It's a lot better.
Last week, he had something
Okay.
amplifier on this that he turned the box around sideways, so when people were talking, it actually projected from the back.
Check, check. Let's see if we have a monitor. Check, level check. Little, not really though. Let's crank this. Um, let's see. All right, well, we're gonna have to check, check. 1, 2. All right, so we're good.
That means you're live.
But where?
Turn it on back.
Can't latch it to anything. It's because it's sewn shut. I mean, I can pull it. Here, let's do it. Sorry. All right, drop it in.
Perfect.
I'm on. Okay.
Everybody else?
I don't know where they go. Where did they go?
Where did they?
And so the seating arrangement.
I think she told Joel to sit next to me because of the way she mic'd him up, and then you, and then Frank.
You're the bookends.
Yes. You're the feature people.
Oh, here we go.
Okay.
Where are we? We're sitting in order.
I'm sitting next to Frank.
Okay, I'll just.
I think you're sitting next to me is what I was told. You go ahead. Yeah.
Welcome, everybody, and thank you for coming this evening to our Science Unsilenced event. I'm Matt Jacobs. I'm director of the Bob Graham Center for Public Service here at the University of Florida. Before I turn to tonight's event, I want to make a couple of quick comments on some other things. First, just a quick reminder that Friday night will be the final Graham Center event of the semester, when we have Douglas Brinkley, historian, someone you might recognize as having been on network news, discussing presidential history at different points. He'll be discussing the 50th anniversary of the landing on the moon and Kennedy's presidential moonshot. So that will be Friday night at 6 p.m. As well. The other quick comment I want to make, actually, we're going to be talking about the sciences this evening, but I actually want to make a quick plug for the humanities really, really quickly. For any of us who are watching the images coming out of Paris yesterday and who were deeply touched or moved by those images, especially if you are neither French nor Catholic, thank your local humanist for that, because it's the humanities folks that have equipped us to understand and to feel the depth of meaning about those events and just how significant what happened yesterday was. And of course, I'm talking about the fire at Notre Dame. So again, thank your local humanists. The humanities take a bit of a beating in public discourses these days about the value of jobs and all of that. So I want to just make that quick plug for the humanities. All right, let's turn to the sciences this evening and the panel that we have here to speak with us about Science Unsilenced tonight. So with this, I want to first highlight that this will be the first in a series of events that will be happening over the next year or two that will be seeking to connect the Bob Graham Center and our principles of civic engagement, public service, and public leadership to the STEM disciplines and science more generally, and really trying to connect the sciences to this question of civic engagement and public service and public leadership. Those will be co-sponsored events with a series of campus partners. But we will be, as I said, moving forward on that. I also want to highlight that one of the key points here this evening is to really connect us to and force us to think about the politicization of science, especially, and how that connects to issues of free speech. This is a central issue when it comes to things like climate science and other issues, and the panelists will be speaking about that. Before I go any further there, I want to also point out that we have some additional events on the Science Unsilenced series of events this week. So tomorrow, Wednesday at 1:15, there will be a screening of the film Let Science Speak, to be followed by a virtual Q&A with filmmaker Christine Arena. That will take place at Smathers Library 100. Again, that's tomorrow at 1:15. And tomorrow at 5:30, Sonia West, who is the Otis Brumby Distinguished Professor in First Amendment Law at the University of Georgia, will offer a lecture and lead a roundtable discussion on health professionals and free speech, and that will take place in HPNP Classroom G101. And again, that's at 5:30 tomorrow. I want to thank our co-sponsors of Science Unsilenced. The events are made possible in large part due to a grant from the National Nonpartisan Organization in program One for All, which is committed to building understanding of the First Amendment and its freedoms. Co-sponsors here at UF include the College of Journalism and Communications. I especially want to thank Dean Diane McFarland for her collaboration on this. UF Health, the Florida Climate Institute, and the UF Department of Geography, as well, of course, as the Bob Graham Center for Public Service here. Finally, it's my pleasure to introduce Andrea Dutton, Associate Professor of Geology, affiliate of the Bob Graham Center, and past Global Fellow of the UF International Center. Professor Dutton investigates, among other things, changes in polar ice sheets as a means of understanding sea level rise in the past and future. Prior to coming to UF, Dr. Dutton graduated with her BA from Amherst College, her master's and PhD in geology from the University of Michigan, and she held postdoctoral and research fellowships at the Australian National University. I'll turn it over to Dr. Dutton, who I know is very passionate about these issues, and she'll lead us through the rest of the evening.
Thank you, Matt, for that nice introduction. And thank you, all of you, for being here to listen to this conversation and to participate in it as we move through the evening. So I'm going to start off just to tell you a little bit more about the event. Cynthia Barnett approached me last year, I think around December, and had this idea of running these series of events through the week. And I immediately jumped on it. I said, yes, this is a great idea. This is something that resonates very strongly with me. As a climate scientist, someone who does a lot of outreach and speaking to the public, I have run into this issue before of wondering, what can I say? How can I say it? What about this audience? And it's something that scientists who are communicating to the public have to think about increasingly. And as Matt mentioned, we've found ourselves in an environment where science has increasingly been politicized and also weaponized, right? And there's a lot of mistruths and misperceptions out there, which obviously as scientists frustrates us very much because we want to set the record straight, but sometimes we feel limited in being able to do that. And so we have assembled a wonderful panel for you tonight here. I'm going to briefly introduce the people on our panel here. And we're going to start off by having each of them tell their story about basically why they're on this panel and what their experience was. And we'll follow up with some questions here on stage, and then we'd like to open it up to you to participate and ask questions of all of them as well. Okay, so to get started, we're going to just go down the line here, and I'll introduce each of them. First, Joel Clement is sitting here on my left. He's currently a senior fellow at the Harvard Belfer Center. He's also an associate with the Stockholm Environment Institute and a senior fellow with the Union of Concerned Scientists. He has a background in climate and energy issues, resilience and climate change adaptation, and Arctic social ecological systems. So before coming to Harvard, Mr. Clement served as an executive for 7 years at the U.S. Department of Interior, and I think he'll be sharing some of that story tonight, because in July 2017, he became the first public whistleblower of the Trump administration, accusing Secretary Zinke of stifling science and ignoring climate change, wasting taxpayer dollars, and risking the health and safety of Americans in the Arctic. He was awarded the Joe Calloway Award for Civic Courage and resigned from public service in October of that year. Throughout his career, I should say, he has focused on the critical need to bridge gaps between science and policy. Please help me in welcoming Joel to the panel this evening. Thank you for being here. To his left, we have Connie Bersok, who worked in wetlands regulation for the Florida Department of Environmental Protection for 30 years. And she was responsible for review and permit recommendations for proposed large-scale projects in wetlands, development of Florida's Uniform Mitigation Assessment Method, and program oversight of the Springs Initiative Program and the Spring Restoration Projects, and administration of Florida's Mitigation Bank Program. In 2012, she was suspended after recommending against a permit for a developer's wetlands mitigation bank, eventually testifying against the DEP for whom she worked while she still worked for them, correct? She was later cleared of any alleged work violations, and she was awarded the Public Interest Citizen of the Year from the Florida Bar Land Use Law Section. And she earned her master's degree here at UF, I would like to mention, at the Center for Wetlands, and is also a certified ecological restoration professional. Thank you for being here tonight, Connie. And finally, we have Frank Lamonte down at the end, who is the director of the UF Brechner Center for Freedom of Information. If you're not familiar with that center, it's a source of research, expertise, and advocacy about the law of gathering and disseminating news across all platforms and technologies. So previously, he was executive director of the Student Press Law Center in Washington, D.C., and before joining that, he practiced law in Atlanta and clerked for federal judges in the Northern District of Georgia and the 11th Circuit of the U.S. Court of Appeals. So prior to embarking on his legal career, he was also an investigative journalist and a political columnist. His work on behalf of open government and journalist rights has been recognized with numerous awards, including the American Library Association's Freedom to Read Foundation Roll of Honor and the National Press Photographers Association First Amendment Award. The College Media Association offers an annual award in his name to honor special distinction in ethical journalism. So he is here clearly to offer us some legal perspective on these matters. So thank you, Frank. Okay, so with that introduction, I'm going to start off with you, Joel, since you're to my left, and ask you to tell us about the story and what you experienced related to silencing of science.
Okay, thank you, Andrea. The mic is working, I think. Thanks very much. I'm delighted to be here for a number of reasons, partly because it's so nice down here. Boston is not so nice right now. But also because I've been touring universities in the last couple of years to talk about this, and I've found some of the most fantastic engagements and conversations come in these settings. So I'm glad to be here with my fellow panelists and you, Dr. Dutton. So looking forward to it. Also, I'm a Mainer, and every Maine family has connections to Florida. So we send you our softies. So my mom just popped by. She lives down here. So my story, and I don't want to spend a lot of time on it because I'm really looking forward to the conversation here. But I was a federal executive at the Department of the Interior for 7 years. I ran the Office of Policy Analysis, which is a team of scientists and economists and analysts focusing on cross-cutting issues around the department. In particular, what I brought to the agency was a focus on climate change and climate change adaptation. For those of you who aren't familiar with the Interior Department, think of the National Park Service, Fish and Wildlife Service, the USGS, the U.S. Geological Survey. So you've got science, you've got conservation, but you also have public lands leasing for oil and gas and coal mining and so on. So you have all kinds of hats that are worn at the Interior Department. So the issue of climate change is somewhat fraught, and you need to approach it in a lot of different ways with a lot of different audiences. And my role was to focus in particular on some particular Americans who are facing the consequences of climate change right now, and I'm talking about the Alaska Natives in the Arctic. The Interior Department also includes the Bureau of Indian Affairs, and we're the federal trustee for American Indians and Alaska Natives. So in that role, their well-being is meant to be part of the mission at DOI too. So I was focused on that. When the election happened in 2016, I was actually in Stockholm at a climate change release event, and the Europeans were freaking out and coming up to me saying, what's going to happen now with climate change? And I said, well, you know, I know there's been a lot of rhetoric about the causes of climate change, but climate change adaptation is such an important thing for health and safety. Of course, they will never come after that work. We'll continue doing our resilience work and adaptation. I'm not worried. And then the transition took place, and it became more and more ominous every day as they seemed to be kind of gutting the agency and pushing the career people away from the decision-making process. But it wasn't until June of 2017, so about 6 months into the administration, I got an email in the evening. I actually got a phone call from a friend who was also a senior executive saying, hey, you might want to check your email. They've just reassigned me to somewhere. I knew nothing about this. Sure enough, I checked my email, and as the senior climate change guy, I was running the policy office. I had just been reassigned. And the reason I knew that it was retaliatory out of the gate is because they reassigned me to the office that collects the royalty checks from oil and gas and mining companies, right? So there was it was as if they flipped me off on the way out, right? So like most career employees, you don't know what your rights and protections are. You're pretty upset about the situation. You quickly need to find out what your rights and protections are. I found an attorney and I said, what do I do here? Is there any recourse? This clearly has been a purge. I was one of dozens of people that received that email that night, none of whom had been contacted in advance, none of whom were part of the decision, many of whom had been reassigned to jobs on the other side of the country and were going to have to move their families, some of whom were undergoing cancer treatments and were going to have to relocate. Most were retirement age, and actually a third of them were American Indians. So it was not only a purge, but there was some real discriminatory action taking place here. So what were our rights and protections? I learned about the Whistleblower Protection Act and the Whistleblower Protection Enhancement Act, and that I could go ahead and submit a whistleblower complaint to the Office of Special Counsel because of this retaliation against me for all of my very public advocacy on the part of these Alaska Natives. So I went ahead and did that. I took the unusual step at the time also, which vexed my lawyer to no end, of publishing an op-ed in the Washington Post on the same day. So if you want to know more about this, you can go to the Washington Post website. They also have, I resigned a few months later, they also have my resignation letter on there, so you can learn a little bit about it. And there was quite a media stir, so there's lots of places where you can find out more about the details of this. But suffice it to say, my life changed pretty quickly at that point. I learned a lot about what being a whistleblower is like, what keeping your voice is like, and I ultimately did resign maybe 3 months later because the administration very clearly was not going to act on climate change. In fact, they were pushing it to the back burner at a time when it needed to be very much at the front for the Department of the Interior. All of those bureaus that I mentioned have very clear assets and equities affected by climate change. So I did resign in October of that year and found myself doing much the same work I was doing before, but now in an arena where I can still have my voice. And I think that has been, for me, the most important thing. I'd lost my job. I could have stayed in the agency in this new job, working with wonderful people, doing things they thought were very valuable. But I wanted to keep my voice, and I had to leave the agency, I felt, to do that. So since then, I've been doing a lot of events like this, and fortunately have landed at Harvard and Union of Concerned Scientists, so I can keep doing this work. And I'm thrilled to be here. I'm looking forward to talking with others who've been in similar situations, because it's a very fraught situation. How each person handles it is going to be very different, and what they have at stake is very different. So I'm very open-minded about how we go about these things, but I feel very strongly about people maintaining their voice and avoiding the climate of censorship that we often find, and we are certainly seeing now during the Trump administration, and what that does to the role of science in public policy and the role of scientists and experts and people that know stuff in public policy. So I'm happy to be here. Thanks, Andrea, and I look forward to talking with you all.
Thank you. Great. And I'm sure lots of us have follow-up questions for Joel, but before we get there, why don't we move to Connie first and let her share us some more about her story and her experience.
Thank you very much. Is this good in terms of sound?
I think
Not on.
tilt it up and,
Is it on?
Is that better?
oh, might need to turn it on. Oh, it's on.
It says it's on.
Light's on.
Hello? Well, that's being worked on. I do want to say how much I enjoy the fact that I'm being back on campus, because it is a beautiful campus, and I always am reminded when I'm here what a great time I had, even though graduate school is inherently stressful. It's just the nature of it. Just remember the good times. Here, let's try this one. How about this one?
Oh, yeah.
Yay. Thank you. Okay, so my story begins with a phone call. It was a Sunday morning in May of 2012, and a friend from St. Pete area called me up and said, "Connie, you're in an article in the Tampa Bay Times." I said, "Really?" She said, "Yeah, front page." Okay. On top of the fold, for those of you who actually read newspapers. And I said, okay, so here's the reason why there was that article. Here's the story behind it. And the gist of it is that in all of my years working at DEP, I was able to apply science to regulation. When I graduated here from UF, I had a good wetlands background, I had great ecology background, and I was ready to go out there and apply it to the regulations. They don't teach you the regulations here as much as you do on the job, and it's ongoing and continuing learning of the rules and regs. But in November of 2011, there was a permit application that came in that was assigned to me for a mitigation bank called Highlands Ranch Mitigation Bank. From the very beginning, it was a little bit odd. First of all, there already was a permit. St. Johns River Water Management District had already issued a permit. Okay. Turns out the bankers really didn't like their permit because it didn't assign them enough credits, and they wanted more credits. So I want to digress a smidgen about mitigation banking if you don't know anything about it. It's a program whereby someone will restore property, enhance the ecosystem, both the wetlands and the uplands, and then be able to put it on the open market as mitigation and to sell them. Each credit can be worth $100,000 or more. It's big business in Florida. And just like real estate, it's very much one of those things where you have to know exactly how many houses you can put on this lot to know whether it's going to be feasible. The same thing with how many credits you're going to get for a mitigation bank to know whether it would be feasible financially. So since they were unhappy with their existing permit, they applied again to DEP for a different answer with some slight modifications. So that was the first thing that was different about this application. The second one was I was given some special directions. Now, normally I'm allowed to just review because my supervisors know me. They know I know my work. And I was told, no, let's do things a little bit differently this time. Don't bother asking any official questions of them. We'll figure this permit application out on our own. The second big difference was the way they wanted it assessed. We have a rule in Florida for how wetlands are assessed. It's called the Uniform Mitigation Assessment Method. I was involved with developing that rule. I know the rule. They said, let's take a different approach to the rule. And so I was told to take a different approach and ignore certain factors such as the importance of time lag and risk of the mitigation success. Okay. Then the other one was, how are we going to write this permit? Let's take a different approach with that too. Well, again, the rules have some flexibility. They allow you to apply the science and come up with the best permit possible. But in this case, there was a critical component that I thought was missing, and that was reasonable assurance. I didn't have reasonable assurance this plan was going to work. But I was given this direction, so being a good, meek, mild-mannered public servant, I said, okay. By May of 2012, I went ahead and developed 2 draft permits, one that reflected my scientific expertise and how it should look, and one that reflected what the agency supervisors wanted me to do. And I was hoping by looking at what they wanted me to do, they'd say, obviously this is not going to fly. This is against the rules, and it's never going to win in a challenge. Unfortunately, that's not what they saw. They said, oh, great, thank you for that revised draft permit, and we're going to revise it even more to give them more credits. By this point, I said, okay, I cannot stand by with this. And I did what I was actually told to do from day one. Always write down your scientific and professional opinions and make sure it's in the file. So I did. And I said, I can't recommend this for issuance. I will not recommend this for issuance. And I wrote all the reasons why, and it took about 5 or 6 pages. The next day, I was on the road. I was out doing training, and I got a phone call on the way back. It was around 5 o'clock from a coworker, and she said, Connie, someone came in and just took that file out of your office. Do you want me to get it back? And I said, no, let it be. Just let it be, whatever happens. 2 days after that, I get a phone call letting me know that I was on administrative leave. Didn't tell me why, but I had a pretty good feeling why. And another reason I had a good feeling, well, not a good feeling, it's actually a pretty bad feeling. I knew at least 2 staff, very good staff at St. Johns River Water Management District that lost their jobs in apparent disagreements with the same project. So I'm just holding on and saying, okay, what's going to happen next? And just like Joel and many other people, I went and saw an attorney. I talked with a number of people about what to do, and I was just biding my time. Fortunately, in Florida, we have the wonderful Sunshine Law, which allows all of these records to be open. So my memo in the file was there, and someone, I don't know who in the media, saw that file, found out what happened to me, because that was public record too, and thus became a media blitz of what happened to Connie Bersok. And that was what was on the front page of the Tampa Bay Times. And it was carried a lot of other places too. I was surprised to find out. So I just went in there and kept waiting my time. I still wasn't allowed to talk to media. That was our rule at the time at the agency, and still is, that unless staff is given special permission, they don't talk with media. Even though I had reporters calling me up, I'd say, sorry, I can't talk. I'm still employed, I think, today. I'm just on administrative leave. So about a month later, I'm reinstated. The official reason was attendance and leave. If you ever hear that, you know that's not the real reason. That was not the reason why. There was an internal inspection that went on. I was cleared of all charges and went back to work, but without having access to that file. That file was no longer mine, and it was passed on to a different supervisor to handle. When the department said, okay, we're ready to issue that permit, it was challenged by environmental groups, and it did go to an administrative hearing, and I was called as a witness to testify against the agency. That was a little awkward, needless to say, to be sitting up there and seeing three of my supervisors in front of me, hearing what I had to say, but I told them what my scientific opinion was. And lo and behold, at the end of the day, actually the end of several days later, the judge agreed that there really wasn't a basis for issuing the permit the way the department wanted it to. And that really is key to, so what happened next is I still worked there. I worked there for another 5 years almost after that, and until I retired of my own accord. But the reality is how I was treated after that, and how many of my other coworkers were treated, was really a total mistrust of staff. And that was really something that I had not experienced in the years before that time in my life, the time of what I call great unpleasantness.
Thank you.
Actually,
Oh, you
I've got
probably
one.
Great.
Yeah.
So, sorry, I'm just taking a moment to process all of that, because obviously, I mean, these issues are, they affect people, but a lot of other people around you too, but it takes a lot of courage to do what both of you have done, and we all appreciate that very much. Yeah. So on that note, Frank.
Yeah, so I'm the one person on stage who looks like a retaliation victim, but I'm sorry, it was inopportune timing for some surgery. I hope it's not too distracting. So I don't have the courage of my colleagues here, and fortunately haven't found myself in that situation where I was staring down that choice. But as a person, as a journalist who has depended on the bravery of whistleblowers and sources to inform the public about what's going on inside of government, I just add my own thanks to the both of you for your adherence to the truth. I mean, when you take that government job on, and I have one too now, and I take that responsibility very seriously. Do I work for the head of the agency? Yes, I work for the head of the agency, but ultimately I work for the public. I work for the citizens of the state of Florida, and I always feel like my first loyalty is to them, and then as an attorney, to the law, to adherence to the truth, and then somewhere down the line is, am I making my agency look good or not? And then if those other things get in the way of that, then by golly, the agency's image has to yield, and then the truth and the interests of the people have to come first. So thank you for putting it on the line for all of us. So my role today is a little different. I don't have a story like that to share. I thought I would talk a little bit about the legal protection that workers do and do not have when they are working in the federal or the state governmental setting, where the free speech protections that the First Amendment provides for workers begin and end, and then also some of the experiences that journalists have had when they've come up against these restrictions on their ability to have direct personal contact with their sources. As you can tell from listening to Connie in particular, and also to Joel, right, it is incredibly important as a journalist to have firsthand communication with the subject matter experts inside of a government agency. It is not enough to just accept a prepared statement from a public relations professional, which often is what agencies would prefer to leave you with. When you get that prepared statement from a public relations person, you're not speaking to the scientist, you're not speaking to the subject matter expert, you're speaking to somebody whose job it is to make it appear to the public that the agency is speaking with one harmonious voice. And oftentimes you learn that, in fact, that's not the case, that there is internal discord within the agency. The subject matter experts, those scientists, those policy experts differ from the political folks at the top of the agency who have different priorities and make different judgments. And it's incredibly important for the public to know that story too. And that's really the job of, that is what separates the just okay journalist from the great one, right? The just okay journalist takes the prepared statement and calls it a day and goes home on time. But the really great ones, the ones like Cynthia Barnett, do more, and they find they find Connie and they find the story, because it is important for the public to know if there is discord between the experts within a government agency, and it's really not, in my view, a proper use of government authority or the authority of that public relations person to cover that up, to conceal it. We have a right to know that. My friends at the Society of Professional Journalists, a very wonderful organization, I'm proud to be on the board of their national foundation, have done a series of surveys of journalists about their experiences trying to get access to the subject matter experts on the beats that they cover. And although those of you who work in the science field may think that scientists have been singled out for being gagged or restrained from speaking to the media, in fact, I don't know whether this qualifies as good or bad news, but in fact, it is a ubiquitous problem among all government agencies, all levels, and among all specialties in journalism. And I'm not going to read you the whole study, but I'll just give you a couple of quick highlights from it. The SPJ surveyed journalists who cover federal government agencies, who cover local government agencies, who cover schools, and who cover the science beat. And they asked each of them a series of questions about their ability to get unfettered access to the experts on their beat without having to get pre-approval from one of these public information officers or public relations officers, and their ability to have uncensored conversations with those experts. And one of the things they found was that when they asked the question of journalists, are you able to get access to an employee at the agency that you cover without pre-approval of a public relations professional, 54% of the science writers said, no, I am not able to do that. So over half said that either some or all of the time I must seek pre-approval before I can get access to the subject matter expert that I need. But I will say that that was dwarfed by the number of people who cover federal government agencies in general, who said 78% of the time they cannot get unfettered access without first seeking pre-approval from a public relations professional. And then the question was asked in a slightly different way: have you ever been banned or prohibited from speaking to the employee of your choice when you asked to speak to a particular employee or even a particular sub agency? Have you been banned or prohibited from speaking to those people of your choice? And 35% of the science writers said, yes, I have had that experience at least some or all of the time. But again, dwarfed by nearly 50% of those who cover federal government agencies, Pentagon, FBI, what have you, said yes. Half of those said yes, I have been prohibited from speaking to the person of my choice in the agency. I've either been denied an interview entirely or I've been shifted to a different employee of the public relations officer's choice. And so this is the way in which government agencies at all levels are kind of using their gatekeeping authority to prevent journalists, and through them, you, the public, from finding out the truth about what is going on inside of government agencies. Now, is there any legal recourse for this? The answer is surprisingly yes, and this is really contrary to what a lot of folks in government authority have been trained to believe, and contrary to a lot of the rules and handbooks and policies that you'll see published by these government agencies. It's very, very commonplace. We're in the midst of doing a study on this now at the Breckner Center. Very commonplace for a government agency at all levels, from the federal all the way down to the smallest school district or sheriff's department, to have a policy on the books that says no one here, no employees, permitted to speak to the news media about anything related to work without first securing supervisory approval. And I can say with a high degree of confidence to you, after studying every federal court case over the last 50 years in which a policy like this has been challenged, that every single time, without exception, those policies have fallen. Those policies have not withstood constitutional challenge. And a policy of that sort is regularly regarded by the courts as an unconstitutionally broad policy. And now here's why. I'm going to, if you go to law school, you'll have a whole semester in constitutional law. I'm going to give you 4 minutes of it right here. And so you listen fast. When you study constitutional law and law of the First Amendment, right, one of the first things they tell you is, in order for there to be a First Amendment claim, you have to have two things. You have to have adverse action by a government agency, right? And you have to have constitutionally protected speech. Well, the adverse action by a government agency, that's easy, right? When you're threatened with the loss of your job, when you're threatened with possible disciplinary sanctions, being put on unpaid leave or what have you, you've got adverse action by a government agency. Good enough. Question is, when is the speech of a government employee constitutionally protected? And the Supreme Court has varied over its history in how much or how little protection it's willing to afford. Here are the four principal cases that bear on the rights of government employees. 1995, the Supreme Court decides a case called the Treasury Employees case. And the bottom line takeaway from the Treasury Employees 1995 case is that a government agency, in that case it was the National Treasury Department, cannot impose a blanket restriction or a blanket prohibition that infringes on the ability of a government employee to go out and give a talk about their area of expertise. This is what the Supreme Court regards as a prior restraint. And if you study anything about the law of the First Amendment, you know that a prior restraint is regarded as the most noxious and disfavored type of government action in the realm of the First Amendment. It almost never withstands scrutiny, right? So put a pin in the Treasury Employees case, because that is about these pre-speech policies that broadly restrict the ability of all employees to speak, right? To speak. Then we get to the situation where it's not a broad prohibition, but it is a one-off disciplinary action that involves not the broad prohibition against speaking, but punishment of a specific employee for a specific act of speech. That's more complicated. The Supreme Court has told us, a case called the Pickering case. Now, just to trace this real quick for you. In 1968, a guy named Pickering writes a letter to the editor of his local newspaper. He's a school teacher, and he's punished for the content of the letter to the editor. The Supreme Court says, no, when a government employee speaks publicly on a matter of public concern, in that case he was writing about a bond issue that the voters were getting ready to vote on, the First Amendment protects the ability to do that, but the court says there is a caveat that if the speech unduly disrupts harmony in the workplace, such that, let's say, Pickering is now unable to effectively function as a school teacher, then the government can punish the speech. It loses its First Amendment protection. So there's a sort of a balancing act that the government has struck in the public sector. That is the law up until 2006. In a different Supreme Court, a much more conservative Supreme Court that is less protective of individual liberties, a case called the Garcetti case. This involves an assistant district attorney in Los Angeles who writes a memo that undermines a criminal prosecution that his boss is seeking. This may sound familiar, Connie. Writes a memo that sort of takes the legs out from under a case that his boss is eager to prosecute. Says this is a bad case and you ought not go to court with that. I'm skeptical of the quality of the evidence. He undermines the case and he ends up testifying for the other side that it is a bad prosecution and he is punished for this. That, says the Supreme Court, is different from Mr. Pickering. And that case, says the court, because the writing of the memo was a part of your job duties. You were assigned to write the memo. That is different. And we do not afford you First Amendment protection for the act of writing that memo. Well, the Garcetti case sends a very brisk chill throughout the realm of government employment because nobody can quite decide what it means to speak in your official capacity as a government employee as opposed to a citizen. And that becomes the decisive question in case after case after case. Then in 2014, the Supreme Court comes back, and again, the composition of the court has changed a little bit. And in a case called the Lane case, this is a true whistleblower case. This is a guy in Alabama who works for the community college system, who blows the whistle on the fact that his college has created a no-work job for a state legislator so they can pay her to do political favors for them. And he blows the whistle on this. He testifies, and he's fired for doing so. And the Supreme Court says, no. That's not what we meant in the Garcetti case. When you talk about things you have learned in the course of your work that is different from doing something that is a work assignment. So you see where the court has now set up these two different buckets, right? I can freely speak, says the Lane court, about things I learn in the course of my work, but in the Garcetti opinion, if I am doing it as a work assignment, as a part of official duties, I lose my constitutional protection. That, says the court, is my employer's speech and it belongs to them. So that is where we are left right now. And of course, the lower courts have to color in all the details and fill out how this applies in specific cases. I just want to real quick say one more wrap-up point before I turn it back over. I love that both of you, but in particular Connie, referenced, I think both of your cases are emblematic of my day job at the Brechner Center is to be an advocate for freedom of information at all levels, federal and state. And really the Freedom of Information Act and its state analogs, like in Florida, the Open Records Act, are really front and center in what is going on right now in the scientific community in our current climate. After the Trump administration took over and many government websites began to be purged of material that referenced global climate change and referenced scientific doctrine that was no longer in fashion with the prevailing administration, journalists and scientists began bombarding agencies, in particular the Interior Department, with freedom of information requests to try to preserve these documents before they could be lost to history and destroyed. And so there's been a quadrupling of these freedom of information requests to agencies like Interior over the past couple of years in an effort to try to rescue these now hidden documents from falling into obscurity.
Great. There's so much to talk about. You guys have some time because I have so many questions. I'm going to ask just one before we turn it over to the audience. I'm going to ask both Joel and Connie to comment on. My experience as a scientist who talks about climate change a lot to the public is that a lot of my colleagues do not feel comfortable in that role, right? And when we talk about First Amendment, journalism students may learn about First Amendment rights and so forth, but scientists don't really ever talk about this issue. And my sense is that a lot of people are afraid to speak because as scientists, we're supposed to be unbiased. We're not supposed to have a point of view or be advocates for something, or that's the perception, that we're supposed to be these unbiased, completely people. And so then people are afraid to then express some opinion about the thing that they, in fact, are the expert on. And so there's a lot of self-censorship that goes on in the scientific community because of this. So I wanted to ask you about how self-censorship kind of played into your experience, maybe not just that one pivotal experience, but your experience as an employee in general. There's this spectrum from self-censoring to being told you can't do this or work on that, or the very public things that we know about. And could you both comment on that? I don't know who wants to start.
All right, I'll jump in. I have a lot of questions for Frank after what you just said, so that's still going around in my head because they're related to this, but there's a very illegal policy right now at the U.S. Geological Survey that needs to be challenged.
I have an extensive collection I'm happy to share with you.
So what's happened in the Trump administration and how it relates to self-censorship I think is important. I think self-censorship is a far more insidious problem than actual censorship. The journalists are often looking for the smoking gun. Where did they scratch that word out? It's a lot harder to find. But what's happened, because every career employee in the federal government knows where these political appointees are coming from on climate change. And they know that if they raise climate change or if they highlight the words climate change in their grant proposal, they're less likely to get the money. They're less likely to get the attention they need. So they're finding other words to talk about. And the effect of that is it takes the term climate change out of the public discourse. And I think that is extremely damaging. And it takes a lot of the people that work on and are experts on climate change away from the decision-making table. So it's a double-edged sword in every way and a real problem. And so I call it not so much censorship in the agency or even self-censorship, I call it a climate of censorship that they've created in the Trump administration, particularly the Interior Department, where you have at the U.S. Geological Survey, where this communications policy is in place that is clearly illegal based on what you've just said, no one has raised their hand and said and challenged that because they want to keep their jobs.
Right.
And that I understand that, and I don't judge people for wanting to keep their jobs. And for some people, they have more at stake than I did when I made this decision, so I can't judge it. But that is a real problem, and we need the public servants in there that are doing the right work and that are experts. We don't want them to all get kicked out. So it's hard to judge, but at the same time, you really want people to draw the line the way you did, Connie, and just say, I'm here to do a job, I'm the expert, this is expert opinion, and this is how it needs to be done. So, I'm in mixed feelings of how to deal with self-censorship, but I think it is one of the biggest problems, and that's why the messaging from the White House or the cabinet is so important and so ominous as it relates to communicating and acting on evidence and science.
Yeah.
In my case, what I saw in my last 5 years at DEP, and I can't speak for how it is now because there has been some changes since that time, there was a lot of, I would say, I could call it self-censorship based on fear, based on anxiety. I had one very good boss, being escorted out at 4 o'clock on a Friday afternoon saying, you're done, because he, again, had made his decision, or his recommendation. It's really not a staff decision, it's a staff recommendation of what the agency should do. But his recommendation was not jiving with what his supervisors wanted. Being given cardboard boxes, 4 o'clock, go away, don't talk to any staff. That really demoralizes a whole group to the point where no one really wants to do anything. Without going into each and every file, it's hard to tell how they might have compromised their input and their reviews. But I think it probably did make some changes along the way in terms of what someone might have done before that climate of fear took over. That's what I saw in my time there.
Okay.
If I could piggyback on, because Joel opened the door for me here, why is it that a policy like one at the USGS, which does say that everyone here who works at the USGS is required to get clearance by a public relations professional before speaking to the news media, why are those so ubiquitous at every level of government when dozens and dozens of court cases tell us that those are unconstitutional? Here's why, because agencies get away with this because almost no one in any government employment is so motivated to speak to a journalist that they are willing to spend the next 2.5 years of their life and tens of thousands of dollars to vindicate that principle, right? Almost no one is prepared to do that. I should have told you the full name of the case that I referenced as the Treasury Employees case. The full name of it is the National Treasury Employees Union case. And who is in a position to bring cases like that? It is not the individual employee. It is a union that represents the employees who is not in a position to be retaliated against, right? And so many people are understandably so fearful and not sufficiently incentivized to bring that case. In the event that someone does get fired so that that person now has nothing to lose anymore, they are now a prospective plaintiff because they have nothing to lose, it is rarely the case, as Connie attests, that you will be given a slip that says, I am firing you for giving an interview to the Tampa Bay Times, right? The slip will say you're in violation of the attendance policy. And so it is almost always murky. It is very rare that an employment lawyer would have a clean case to take to a judge saying this person lost their job for no other reason than the granting of an unauthorized interview.
And what's interesting is that when I had the internal investigation of why I was on administrative leave, they didn't really question my attendance and leave. I was questioned by the investigators about, did you leak information to the press? That was what they wanted to know. Right. And there's a funny story about that, is I was so careful. I mean, I had it drilled into me, do not talk to the press, in the years before that happened. So I said, okay. And I would run into a local reporter in Tallahassee sometimes at social events. You know, see him in the grocery store, other places, and I ran into him, I saw him one time at an art opening. And I said, oh, I'm not even gonna go anywhere near Bruce. And so, I mean, it's like I would have loved to say hi to him, but you know, if someone saw us talking, they wouldn't know what we were talking about. Someone could go back and tell my boss, oh, Connie's talking to a reporter. So I left. And when I told that story to the investigators during my internal investigation, it became public record. That investigation became public record after I was put back into my job. And then Bruce, the reporter, found this interview, and he thought it was quite humorous that, you know, that was really the reason I couldn't talk to him. He said, now I've heard some really bad excuses by why women wouldn't talk to me at a party, but this one is really crazy. But that was really where we came from. I was told, you talk to reporters, you lose your job.
Wow. Okay, do we have a mic for people in the audience or not? Maybe not. Okay, yes, over here.
The news media policy at USGS is actually very consistent with the First Amendment as it is written. As it is being implemented, it is not consistent with the First Amendment. What has happened is that scientists at USGS for however long, decades, have been able to speak to journalists unfettered. A journalist can call them directly. A scientist gets to talk to the journalist without going and asking permission until the recent administration. That is where it has changed. The policy has not changed, but the insistence on a different behavior has changed. There's a story about that, in fact, in the LA Times.
If I can just respond to that, the policy actually has changed. They've written a new memo that actually it memorializes their new approach. So that memo is considered their new policy, and the memo is what can be challenged at this point.
So I work there.
I believe, I assume that.
Yes. But the thing is, they have not put this in writing. People have requested it and requested it and requested it, and it is not in writing. And anyway, it's a big problem.
Yes, please.
I have a question, a related question. I also work there.
Bless you both.
There is.
Still there.
Thank you.
We are the public relations people that you were speaking of. There is a written policy, a code of ethics, at the Department of the Interior, which everyone from the Secretary of the Interior on down is required to sign annually, stating that he or she has read and intends to comply with. And that policy about scientific freedom of speech states that everyone at the department has an obligation not only to do ethical science, but to make the public aware of that ethical science. I would ask Joel and Frank, all three of you really, to comment both morally and legally whether or not you'd consider it compliance with that policy if the science is published in peer-reviewed journals, but the scientist is not permitted to discuss it with members of the public.
Well, Frank, I'll let you go with the legal side of it.
Yeah, I'm a journalist and a lawyer, so I can't speak to morals. Asking the wrong guy, lady. But legally, the devil is always in the details, and this is the most frustrating interaction that people always have with lawyers is the "it depends" answer, right? And but I'm going to give you the "it depends" answer, which is, if there is a range of interactions the government employee could have with a journalist, some of which would fall within the protection of the cases that I've discussed, and some of them that would fall outside under the Garcetti case, right? So an example of where you would lose the protection would be you do a peer-reviewed piece of research, it appears in a professional journal, and then you're called upon in the course of your employment to say, give testimony in front of Congress or give testimony in front of the state legislature. At that point, your speech really is your boss's speech, and if your boss wants to take that speech and take a blue pencil to it and change everything to say "not" in there, they get to do that, and your choice is to resign. I mean, that's the way the First Amendment works. On the other hand, if you wanted to, say, write an op-ed column in a newspaper or speak to a journalist, particularly if you wanted to do it on your lunch break, you wanted to do it, not in a setting that seemed as if you were holding yourself out as the official spokesperson for the agency, I think that you'd plainly be within the boundaries of what the Supreme Court regards as protected speech. But the more that it appears that you're being held out as the public face or spokesperson of the agency, the less freedom you'll have.
And I'm not going to speak to the moral side of it either, although ethically, it's just absurd. This is not public service. We take these jobs, you took these jobs in the interest of the public. As Frank mentioned earlier, loyalty isn't to a particular political appointee, right? It's to the taxpayers, to the Constitution. You're doing the job, you're a public servant, and you feel strongly about that. And that's one of the biggest things I regret about not being in that job now, is not being a career civil servant. But to say, well, there's science out there, you journalists need to go figure it out yourselves, you can't talk to the experts, is just not public service. Where is that okay? All right, so whether there is an ethical question, legal questions, it's for others to determine, but it's just absurd. And I have a hashtag on Twitter, not public service, that I will throw out there every time I hear another, diatribe from one of the politicals saying why they're doing what they're doing.
From the state perspective, at least from DEP's agency head, we would not even be allowed to submit an article for publication or submit an abstract to go to a presentation, again, forms of communication, without having prior approval fairly high up in the review chain. And then once that was done, then you would be allowed to go and talk to, at least at conferences, and be able to talk on that discussion. But other than that, it pretty much limited what we were allowed to do in terms of general communication. But I agree with you. I mean, communication is key to science.
If I might add too, because you you both prompted another thought here. I mean, one of the most frustrating things, both as a litigation attorney and as a journalist, is when the informal word-of-mouth culture of the organization does not match up to what is on paper, right? And that is so frequently the case. I have told journalists who've called me with this problem before, no one at this agency is allowed to speak to me. I've said, well, go get the written policy, get the handbook, get the employment contract, and bring it to me. And just as you're describing, the written policy, the handbook, may be quite good. It may be quite favorable, but the employees will come back and say, that's not what they're telling me. What they're telling me is that you don't want to be like Fred, do you? Fred got canned for talking to the press, and you don't want to be next. And so there's frequently a beneath the surface culture at the agency that does not match up with the standards that they hold out publicly. And that's the hardest thing as a litigator to fight against, right? Because, of course, the moment that you file the challenge saying, I'm stifled from speaking to the media, the defense will come back with the policy and say, what are you talking about? Look, it's right here in writing. You're free to talk all you want.
Right. Other questions from the audience? Yes.
Hi, my name is Tomer. Lovely to be able to hear all of your perspectives today and just discuss something that was mentioned before. Oh, sorry. The memo that the USGS, the internal memo that was issued by the USGS, wasn't directly issued by the USGS. It was actually something that was written by Secretary of the Interior David Bernhardt, I believe, and then it was echoed in another internal memo by the USGS, which has since been cited for work by Michaela Noble, who is the director of the USGS. So just a clarification there, which is why it might be difficult to be able to find that kind of information.
Yeah, and if Bernhardt writes it, right, that's policy, and he's recently been confirmed as the secretary, and they were just announced today that the Inspector General is going to start investigating him on some more ethical breaches. So it's fantastic to hear how things are going with leadership. But, yeah. Thank you.
There's a question back there.
Hi, my name is Lacey Lingelbach. So my question kind of goes more into the public distrust of science. I feel like it's so prevalent now. When do you think this public distrust started, and do you think it started when scientists became more censored in government agencies?
I know you want to take a crack at this, but let me just say that
I'm purely a moderator tonight. I still like my job.
I fair enough.
Here's my card.
This distrust in science was no accident. In my view, this was an intentional phenomenon. And I think we can look to the tobacco industry maybe first before we talk about the oil and gas industry. But the intentional disinformation campaigns and the attempt to mislead the public about what science is and how much evidence can be trusted, this was a very active and intentional effort on the part of industry. So this isn't just, gosh, isn't it weird how society is starting to distrust science a little bit more now? I wonder if this is a thing, and maybe this is the natural evolution of public discourse. This was intentional, and millions of dollars have been poured into the disinformation campaign now related to climate change and fossil fuels. But the playbook was very evident with tobacco as well, saying no, tobacco doesn't cause cancer. The Union of Concerned Scientists, where I'm a senior fellow, has what they call a disinformation playbook. You can go on to their website and find it, and they map out each of the plays that these so-called experts are using each time to question the science or to deflect from the science or to create red herrings. And it's fascinating to read because you read it and you've seen this over and over in the public discourse now. You see these events and you go, holy cow, this was intentional. This isn't just, suddenly Americans are too cool for science. This was an intentional and very well endowed activity on the part of industry.
Other questions?
Sorry, so there's an answer to that.
Yeah,
right? We need to act in response to that, right? I mean, that doesn't need to be that way, and that's why voting matters. That's why engaging on these issues matters.
Hi, sorry. I was going to ask a question about whether or not, or rather, what opinions you have about the paper that came out in Science magazine. The concerns of young protesters are justified, and they supported directly the mass mobilization of the climate movement due to this emergency that we're undergoing the necessity to act resolutely and quickly to limit global warming, halt mass extinction, and preserve the natural basis of our food supply, and etc. As a undergraduate, I'm looking at graduate school next year at University of Florida from an environmental engineering background and wildlife ecology, mostly climate change ecology background. I mean, I was really worried that whatever work I do in the future, I'll be silenced due to my direct necessity to implement, or rather push this policy and really spread the science to people. I apologize, I'm a little nervous talking in front of crowds.
Yeah. I feel strongly about what I've been hearing lately, particularly from youth about these issues. And there's a great, the petition now to support that youth perspective is going around in all the science circles. It's getting great support. This trend that you raised in the last question does need to change. We need to reverse this distrust that's been manufactured. And it's this next generation of professionals that are going to do that for us, frankly, just by doing a good job, having ethics, focusing on public service and evidence-based decision-making. I mean, there's just nothing better, right? And so for young or early career people in the sciences, I say, hey, get in there and work. I hate to say this now, but go work for the federal government. Doesn't seem like a good time to do that. But that's where you're going to be needed. Half of the federal workforce is retirement age. There's going to be a transition, like it or not. So there's a huge opportunity for people like you to engage on this stuff and lean in and ensure that ethics and scientific integrity are at the front.
Or state agencies or local agencies. It's amazing how much can be done on a local level, and that's really where a lot of the changes are happening, in Florida in particular, where the local governments are saying, we don't care what, and I hate when they use the term Tallahassee because they really mean the legislature or the governor. They really don't mean the people that live there. But Tallahassee, we don't like what Tallahassee is telling us. We're going to do something different. We're going to take charge of our county or our city. And yeah, any place you can get yourself into a position where you have that ability to apply your knowledge, go for it. Really go for it. And I'll have to say, this is another funny story. So after I had my little time of great unpleasantness, and other people had similar situations, they could feel the pressure coming down on them, oh, I've got a bad project. I heard someone say that they were just going to Bersok their way through it.
Congratulations.
And what they really meant is just keep sticking to your message, put the science down, write it down. Those memos to the file are just as important to all the data collecting out in the field. Just do it.
So we need to wrap things up, but in doing so, I'm going to respond to that last question a little bit and say that one of my graduate students came in the day after Trump was elected and said, what do I do? Do I need to change careers? It's kind of like what you're saying. It's like, no. Don't panic, right? Like, if we don't have a voice and go out there and do our science and share it, that leaves an empty space that someone else is going to fill, right? And one time when I was nervous about talking to someone doing a TV documentary, it was my first documentary, and I thought they could get me on tape saying something and they can twist my words around and it'll be awful. And I called my friend Michael Mann and I said, what do I do? And Mike, that's the advice he gave me. He said, if you don't do this, someone else will fill that space. And I've never looked back. Please join me in thanking our panelists tonight.